So, did you submit comments to the European public consultation? Did you submit comments?
To the consultation?
You did as well, I know. So, no, thank you.
I know the term, but not the.
The debate.
No.
So if I put in the context, you would be able to say, you know, we understand the way Commission consideration works, it's a how we take so
Right.
there's a big debate that is because I got crazy and I was like, you know, this is enough. So it's really like a stupid
We did have a concept in this problem during the system data mining discussions in the European level because publishers yes, and of course it's a vibrant topic as well. So
Good morning, ladies. Oops. Good morning, ladies and gentlemen, and welcome. This is workshop 6, European Copyright in the Digital Age. My name is Konstantinos Komaitis, and I am a policy advisor with the Internet Society. We are all gathered here today to discuss possibly one of the least controversial issues of our time, and that's copyright. Before I let our panelists introduce themselves, I would like to ask you to just in one word, the first word that comes into, to share the first word that comes into your heads when you hear copyright in the digital age. Yes, please. Thanks, Ellen.
Anyone?
Anyone?
Lobby.
Lobby. No, just shout. Actually, you don't need a microphone,
I'll
yes. Just shout. Confusion. Fragmentation. Enforcement. Creativity. Pirate. Good. Piracy. Authors. Remuneration. Should. Fair use. Anyone else? Anything else? Uncertainty. That's great. So it's very interesting to hear that no one thought of users, but it's okay. We are going to try to put users into the equation and start talking about it. As you all know, and some people have already expressed it, copyright law is a very complex regime, that it has become even more complex because of the internet, because of the nature of the internet and the way the internet works. Even though the topic of our discussion today is European copyright law, I would like us to start by focusing onto Europe, but then progressively move on to expand it a little bit and think of copyright law as one of those core elements that need to be addressed, and we need to start answering the questions that have been posed for also many years, because currently the debate is highly fragmented, the discussions are not moving forward, and because of this status quo, we find ourselves in a position where technology is at stake, innovation is at stake, the rights of creators and authors are at stake, the rights of users are being questioned. So we really need to start finding innovative ways and creative ways, since we're talking about copyright, to move a little bit past that. I will try to put this discussion a little bit into context, and then I will turn to the panelists and I ask them to introduce themselves, as I said. So, generally speaking, and anyone who has studied law and copyright law in particular knows that there are two main pillars to copyright justification, namely the creator incentivization as a means of ensuring public access, as well as the creator reward. So we all know that copyright, and we have come to realize how important copyright is in our societies, and how important copyright has been in progressing various values, including that of knowledge and science. So the idea that we don't need copyright is really not valid. And I would like us, at least for the next hour and a half, to start on this basis, that we need copyright, and we need to find a way to address the various issues that have emerged because of the internet. One of the other things, however, that we are increasingly becoming aware of is that copyright needs to change. Its legal infrastructure needs to change, and it needs to adapt to a new reality. And that new reality is the internet. The internet is here to stay. It's not going to go away. And the sooner we realize that, the better it will be for our discussions on copyright. So, someone said it here, there is a certain degree of uncertainty in how copyright operates when it comes to the internet. And that generally, it has been evidenced that it has a spillover effect on innovation, entrepreneurship, and general entrepreneurship. There is academic literature. Can you please close the door? Thank you. There is academic literature that actually suggests that right now it's very difficult to get funding on business models and ideas that have copyright, that may have copyright implications. So music streaming or video streaming, etc. So we are faced with an outdated system that is trying very hard to integrate itself into a highly disruptive technology, and that is the internet. However, we have come to realize a lot of things as well. We have come to realize that despite the disruptive nature of the internet, copyright is also able to provide a lot of answers, and it's also able to help newcomers in establishing themselves and incentivize them in order to create those new ideas. Now, the debate is taking place globally, and it's taking place regionally as well as nationally. In Europe, the debate has been taking place for many, many years, occasionally not as strong as at the other side of the Atlantic, in the US. We still haven't seen also in Europe some laws that a lot of people have been questioning, like SOPA and PIPA in the United States. However, what we have seen in Europe is a more active participation by users. ACTA was a very clear example. It was because of the European citizens who were willing to take on the streets to protect what they felt was in jeopardy that ACTA actually failed as an international treaty. So the European Union has opened up, the European Commission opened up a consultation some months ago. There was an overwhelming amount of submissions to that consultation. All our three panelists have submitted comments to that effect. So there is a very strong dialogue taking place in Europe, and this dialogue is a great opportunity to start figuring out some of the details that have been at the back of our heads, have been debated, have been highly discussed, and try to figure out how best we can harmonize copyright law throughout Europe. So I will stop talking because this is certainly not about me, it's about you guys. And I will start with Guido. Please introduce yourself and tell us a little bit about what, how the German libraries are seeing copyright, the copyright discussions, and how you feel about it.
Thank you. Good morning, everybody. My name is Guido Janssen. I'm from the German Library Association. I'm responsible for international cooperation there. I have to add, on a side note, that I only learned this morning that I'm on this panel. So I'm now trying to be very creative. I just prepared these very comprehensive notes to tell you a little bit about the point of view of libraries as one group of users, in a way, around copyright and digital content. I think what many people don't seem to know, or what many people aren't aware of, also on the political level, is that libraries, actually, when it comes to digital content and to ICTs, are early adopters. Libraries, at a very early stage, have provided access to internet, to multimedia. They have organized workshops and trainings for users. And libraries still, to this very day, constitute for many, many people in Europe the only point of access to the internet. Now, this is a role that libraries are very aware of, and a recently published trend report from IFLA, from the World Library Association, highlighted that this function of libraries, the societal function, is going to grow in the future, in particular when it comes to providing people with information skills and to ensure information literacy. Now, what does this have to do with copyright? The problem for libraries is that the copyright in many countries with regard to print media has been very well regulated. The role of libraries has been regulated, and there is an agreed consensus and an agreed, compromise between the interests of right holders and the interests of users and user groups such as libraries. For digital content, this has not happened, and that means that, for instance, in Germany, publishers can decide whether or not they want to grant libraries the right to license e-books and to get e-books. For this reason, the European Library Association, an umbrella organization called ABLIDA, has launched a campaign quite recently called The Right to E-Read, which tries to lobby for an international, at least European-wide, regulation around access to e-books for libraries, which doesn't mean that libraries want digital content for free, certainly not. It also doesn't mean that one library in Germany buys one e-book and then all German citizens can somehow download it or something, but it means that there should be a framework which enables libraries as access points for many, many people to provide e-books and digital content in the same way that libraries have for decades provided print content. And I'll stop here because I think my colleague from the International Federation of Library Associations will have something more to say on that.
Thank you very much, Guido. For those of you who haven't met me, my name's Ellen Broad. I'm the Manager of Digital Policy and Projects for the International Federation of Library Associations. I'm going to expand my comments a little more than libraries today so that it's not a completely library-centric panel, although those are the panels that I love. In my past job, I ran an NGO in Australia called the Australian Digital Alliance that provided copyright expertise to not only the Australian government, but governments in the Asia-Pacific region. So I can kind of expand into the other user groups and creators that we represented. I'm actually just going to base my opening comments kind of responding to some of the words that we heard in the first 5 minutes of this panel, because I think they really articulate the wide reach of copyright at the moment and the many issues and opportunities that are ahead of us. The first that I wanted to pick up on creators, because increasingly what I'm seeing in the European context particularly, because I know a number of us have now seen the draft impact assessment that was released through Statewatch, I see increasingly creators being lost in the copyright equation. In the European copyright consultation, for example, there is an increasing focus on distributors. We've seen the internet tree that was released by DG Market, and at the base of that tree are the distributors. So it's all about facilitating that global copyright exchange. It's all about licensing. It's all about distribution. But what I fear for are the original intended beneficiaries of copyright, which are the creators. To give you just one example, and admittedly this is from a library perspective, but we are also creators of content. The internet does not, it offers as many challenges for individual creators as it does opportunities. It is an extremely effective distribution network, but almost impossible to police as an individual creator where there is infringement of your work, even where there are mechanisms in place in the copyright regime for that to be enforced. And to give you just one example, it's quite common if you're a blogger or if you're an academic and you have an online web presence to find your content being scraped and added to other note-taking sites, where quite often it can be republished as CC BY or open domain, public domain I should say, or CC0. We had an issue where we found 627 instances of content having been added to a public domain website. In compliance with the takedown and notice scheme that was in that jurisdiction, we could fill out online forms to have that content taken down, but we had to fill out 627 forms to have each of those URLs removed. And they were extremely cordial, the website. They explained to us that this was the way in which that content could be taken down, but the reality is for a lot of individual creators, you're dealing with a system that enables the kind of endless refraction of that content throughout cyberspace. So I think I don't know how we're going to address that, but I wonder if that's something we'll talk about today. Very quickly, enforcement is something that I think will also be very interesting coming up. Libraries and archives, we're currently at WIPO advocating for an international treaty that preserves copyright exceptions and limitations for libraries and archives. The European Union is strongly against any exceptions and limitations in this space. However, when we go to enforcement, quite often we move with enforcement as something that is unquestioned, as compared with access, which I think should be as equally profound and necessary. So there's a broadcasting treaty being negotiated at WIPO that would be unprecedented in the level of rights it gives right holders, but the nature of that work is not questioned as much as exceptions and limitations. The third is fair use or flexibility. A part of the European copyright consultation will be whether it is time to adopt an open-ended exception. I gather that fair use is definitely not palatable to many within the European Commission, but I do think we will talk about permissionless innovation and why that's important. I might stop there because that was just the original thoughts.
Thank you, Ellen. Matthias.
Good morning. My name is Matthias Schindler. I'm a project manager at Wikimedia Germany. Our organization is working from Berlin in order to promote the creation and dissemination of freely licensed content, including Wikipedia. I work in the Politics and Society department, so we are dealing with topics including copyright, participation in the consultation. The last two larger discussions we're engaged with were the orphan works discussion in Europe and discussions about the Public Sector Information Directive, which also had a big chunk of copyright implications. Depending on the demographic and the professions where people come from to various workshops, I sometimes try to remember people as Wikipedia is, according to more or less reliable statistics, a place where roughly 20 million people have contributed to. So if Wikipedia is seen as a stakeholder, it could fall into the stakeholder group of authors rather than distributors. But in some cases, the distinction is blurred, so it doesn't really matter about the categorization anymore. However, Wikipedia has one big disadvantage, and that one is its aim to comply with copyright law. If we do so, it creates a huge overhead in compliance and research effort, and it means that a large chunk of content will never be able to be used on Wikipedia because of the legal uncertainty involved in the inability to check licenses and to check copyright status for a large share of works.
Thank you, Matthias, and thank you all. So I want to take something that you said, and you talked a lot about regulation and the impact that regulation is having, and the way we have been approaching copyright is essentially an extension of what we have always been doing. We have been going through very hard regulatory regimes, and we have tried to figure out everything that we can about copyright and how to prevent things from happening and everything. And this obviously is not really working, especially now because of the internet. So I would like to ask, before I step in Europe and ask you what the current state of copyright, what do you think the current state of copyright law is in Europe, whether we need to also start thinking towards different means of regulation. And by that I mean more self-regulatory initiatives. We see them already happening. We see them very strongly happening in the United States. In the UK also, we have voluntary initiatives that are emerging. So do you believe that it is partly, the state that we are right now is partly also because of the fact that we have not been able to figure out innovative forms of regulation for copyright, and we have just followed the path that we always have followed.
Should I have first go at that? I think fragmentation, again, is the word that comes to mind that has been mentioned also here. Obviously, we do have a lot of different approaches in different European countries. And, and the question now is, to which extent can we keep that diversity? Because some models may work well in some countries and some may not work so well in others. And I know, for instance, that some countries did not partake in this campaign that I just mentioned for, the right to have ebooks in libraries, for some sort of like state regulation, some law to enshrine this right for libraries, because they said we have found models in our country which really worked well for us. We actually discussed with publishers and with publisher associations, and we came up with a model where publishers can choose between 3 different, say, types of license for libraries, and they themselves can determine into which type of license they want to put their titles, and that then determines the conditions. And people in those countries then basically said, well, if we now start talking about a state regulation, and even on a European level, that would actually imperil what we have already reached. So I think from my point of view, the question very much is which road should we follow? The German Library Association, from the German point of view, supports the idea that we actually want printed books and e-books to be treated entirely equally. So that basically the legal status of print books is also applied to e-books, at least when it comes to for instance, distribution, dissemination, and web production, etc., etc. This, however, may not work for other countries in Europe, and so do we need some sort of like minimum level agreement, which basically just sort of like gives a more general idea about usage and exceptions and limitations of copyright, or do we need something which is very, very precise? That I think is still to be decided.
So, talking of voluntary regulation, this is actually something that libraries and consumers and many other groups are very familiar with, because the licensing environment is a form of voluntary regulation in that exceptions and limitations, for the most part in legislation, they can be overridden by voluntary regulation. I'd say for libraries, the licensing environment and the nature of this voluntary regulation of terms of use, for the most part, isn't working. And that's for 2 reasons. The first is that it, by its nature, overrides the exceptions and limitations that we do have in place in law, but also it changes the dynamics of what a library is. It changes the role of these institutions from being public interest institutions whose mission should not be dictated by, particularly if you're a public library, by whether they're physically located on the premises or not, the nature or the way in which they read the book. So, for example, they may have a visual impairment and require the book in a different format. You may have different understandings of time for your borrowing period. We need to think very carefully about the extent to which the private market can replace the role for exceptions, limitations that were decided in the public interest. And I think where we see the decisions being taken that to an extent it doesn't work is in the United Kingdom, who have just introduced a new provision in their copyright law that prevents the override of certain legislative exceptions and limitations by contract. And I think that is recognition that I think we will increasingly move towards a licensing environment. Just this week, the Director General of WIPO mentioned his vision for a seamless global market for content, but I do not think that that will replace the need for legislative reform. I think it goes to what Guido said, that there will still need to be a minimum standard to ensure that some of the more holistic public interest ideals of copyright, which have been in place since the beginning, are maintained.
Thank you, Ellen. And just as you can see, we only have 3 panelists, and this is meant to be a discussion. So when you hear something and you would like to react, please do raise your hands and ask questions. This is not meant to be all about our panelists. So, okay, this is about copyright in Europe. So what do you think is the current state of copyright law in Europe? And I will turn to you, Ellen, before I go to Matthias, because you are working for an international organization which is based in The Hague. And you are also dealing with issues as they emerge internationally. You participate at WIPO, I've seen you there, and you also have to deal with the European in the European context, and you represent a whole bunch of libraries, right? I mean, you have such a diverse membership. So what do you think the current state is, and does it facilitate the state that we currently experience in European copyright law? Does it facilitate bodies like libraries, but even beyond bodies, if you know, even beyond libraries, if you know about other bodies, the challenges that they may face?
So the IFLA put in a submission to the European Copyright Consultation that really just repeated the reasons behind being at WIPO, which is that increasingly libraries and archives and a number of different groups are operating across country borders. So the territorial nature of copyright is a real problem. In research, increasingly we're undertaking international research collaboration as one example. We also pointed to the licensing issues that I've talked about and the need to move towards a more open regime. This is part of what we've been advocating for at WIPO, although we haven't gone so far as a flexible, open-ended exception, because that would be very controversial in the WIPO context. To give you an understanding of how it relates to the European Union, something that has been very frustrating is that the European Union is currently undertaking its copyright consultation, and I think the recent decisions that we've seen of the ECJ indicate the extent to which the InfoSoc directive in the European Union is in need of change. That we are asking questions at the European Union level, like should hyperlinking be an infringement of copyright, really struck me coming from outside the civil law tradition. And I know that that's something that changes the nature of how we consider copyright in the European Union, that it has a very strong, it is a civil law system, it has a very strong moral rights tradition. So these do differentiate it from the common law countries, but so I've been involved in the UK copyright reform peripherally, some of the US actions, some trade agreements, and in Australia. And the biggest observation I've had so far of the European process, not only for libraries and archives, but for other groups who have been involved in the consultation, is sometimes we're talking about very basic aspects of the internet. So when we talk about hyperlinking, for example, or if we talk about indexing and caching, and I would argue also text and data mining, but I know that there's very strong views on text and data mining, but we're talking about very basic elements of a functioning internet. And in other countries that I've been involved in, the question as to whether these should be protected by copyright is never really treated as a serious question, as in it's simply, well, if we need to be thinking of a productive digital economy first, and then how we can actually ensure that the legitimate rights of creators are protected. I said to one of the European Commission officials, if you actually went so far as to consider legislation, for example, that would consider certain necessary functioning of the internet as potentially open to a licensing approach, then that's at odds with the global internet economy. In other jurisdictions, we have not ever, so the Irish copyright consultation, the UK copyright consultation, Australia, the United States, these are no longer serious questions for consideration. We're also seeing the increasing uptake of flexible regimes around the world in the Philippines, South Korea, Singapore, Israel. So to be considering certain reforms in the European Union that potentially put it at odds with the rest of the world, it seemed strange to me that some decisions were taken about what is a global internet from a very European perspective. So that's perhaps my just observations as to how this has differed for me, where it focuses very much on the internal market here, whereas some of the other reviews that I've been involved in focus on its global competitiveness.
Matthias.
I fully agree with the assessment. We have been trying to figure out the process, how the series of 70 questions for the European Union consultation went. There might be psychological reasons for adding these questions to have some kind of plausible deniability scenario in which or a scenario in which the Commission can properly claim that all interests of stakeholders have been considered, even if Commission doesn't see this as a policy option at all, and never has been seen. But that's a hypothesis. I would hope so, that this hasn't been ever a policy option to consider breaking the internet by means of policy of copyright.
Thank you, Matthias. So actually we've heard that, and as we mentioned in the beginning, the Commission has launched a huge effort to reform potentially copyright, and they had a call for public input that, and they received actually, as I said, an overwhelming amount of responses. I know that all these three people have submitted comments, and I see faces in this room that I know have submitted comments. So I would like to just go and ask you briefly whether you, how you perceived this process, whether you whether you welcomed such a process, and what are your views of this European effort, both in terms of process and substance, and if you can be just a little bit brief. I don't want your full submission, I just want the feeling that you got from that. Thanks. Matthias, I'll start with you.
It's now about a decade after InfoSoc was created, and there should now be evidence on the effect of the InfoSoc directive, and there should be more data available than currently is about the implications of certain copyright decisions. So apart from the consultation and certain methodology of evaluation, copyright remains far too faith-based, and I'm not sure if the European Commission will be able to introduce more data than currently is in play about the reform debate. However, the consultation was a great opportunity in both answering questions and then to encourage people into participation. So half of our time spent went into answering the question, half of the time went into building up an infrastructure to allow people to participate in the consultation more easily than the Commission allowed. And we have seen other efforts, including Copywrong EU, fixed copyright. Some of the software was released under free license, and representatives from other parts of the industry copied the software, pre-filtered with their answers, and encouraged their members to participate in it. So the high level of participation is not just an indication of the topic hotness itself, but also of the skill set of groups involved to mobilize their base.
Thank you, Matthias. Ellen.
So I've already told you in a nutshell what our consultation response was, so I won't repeat it. On the process, perhaps I'll just say what I'm really interested to see from the release of the white paper and the future progress of this is how DG Market, who is undertaking the copyright consultation, sees the white paper and the impact assessment being integrated with some of the other reports that have been released by other DGs, like DG Research, for example, that that acknowledge the overlap between copyright and research, for example, and ICTs, because I think that there's a lot of other great thoughts being had around copyright in other DGs in the European Commission that I'd really like to see integrated into the response from the European Commission. They've had a challenging process in having received over 10,000 submissions, and I know that there's been some concern around how they intended to analyze those, whether it was possible to analyze those. I know a part of me wept bitterly internally when I realized that potentially my 40-page submission wouldn't be read in detail, but that's fine because I learn a lot about European copyright in the process. But these are part of the nature of the beast. What I think would be really good is perhaps, so we know a white paper is coming out, we don't know exactly what it will say. I think it would be a shame if it said something as simple as we should issue guidelines for member states interpreting the original InfoSoc directive, because I think more change than that is necessary. Perhaps it's time to undertake a review of the InfoSoc directive by a non-European Commission department. So in the UK, they had an external review, the Hargreaves Review. In Ireland, it was done by Professor Ian O'Dell. In Australia, it was the Australian Law Reform Commission. So all of these reviews were kind of taken out of the agency to consider somewhat objectively the usefulness of the current regime.
Well, I can only echo what Ellen has said, in particular the skepticism around, or the questions around how all this input that has been received is now going to be digested and actually turned into some meaningful messages, which then can inform policy making. Just to add that in Germany, obviously, due to the federal structure of the country and this to devolved responsibilities, the input from cultural institutions was coordinated by a body called the Deutscher Kulturrat, the German Council for Culture, so to speak, and that really worked very well. But I wonder, for instance, how representatives from small, medium-sized enterprises actually made their voice heard, because we talked about this we heard about this in the plenary this morning, and I have to say I found the entire process of the consultation quite exclusive. I can't see that people, for instance, entrepreneurs who are self-employed, who run small, medium-sized business, or even their lobby groups who are working on a voluntary basis very often, can give their input into this document, which was quite long-winded and required a lot of time for completion. So I'm not sure whether the results that the European Union got now, the input, is really a sort of like fair reflection of positions and views of the different stakeholders in European societies. But I mean, it's better than nothing, of course.
Thank you very much. Anyone in here who has submitted comments to this consultation and would like to say something, that would be great. And I am following Twitter, and I know that there is an artist in the room who is wondering whether he's the only one, and also has concerns about fair use, issues like fair use and parody and sampling and the loss of creators. So I think that whoever you are, please identify yourself and please tell us why you are so passionate about those issues, and whether you think that copyright law in Europe and the process that we are undertaking right now can address those issues. I can tell you that also a similar effort, only to a much lesser scale, has been undertaken in the United States. The United States Department of Commerce took on the mission to ask questions. The difference that we saw, and this is actually where I would like the discussion to progressively move, was that, interestingly enough, the United States Department of Commerce asked questions more about technology, asked questions about the relationship between copyright and technology in terms of the compatibility and how copyright law can move towards facilitating the evolution of the internet. So, anyone that would like to just make a comment based on your own submissions? Oh, fantastic. You're the artist? I am. Fantastic. Thank you.
Yeah, so, okay, I tweeted that because I'm also American, but I've been researching in Europe for the last year. So as a digital virtual artist who engages in sampling and parody, etc., I think that most artists existing in that space only find out what the law is once they've broken it. And also, the law has changed depending on what country you're working in, and artists don't really care about national borders. So there's a kind of working with the US and Europe and getting an idea about what this word copyright really means and what artists can do, and then getting that out there to them in a way that they can understand and then act appropriately. Because I don't think that most artists really want to break the law. They just want to be part of a discourse. So.
Thank you very much. So, anyone else? Please, John.
Hi, I'm John Laprise from Northwestern University. I'm a historian of technology, and I really would like to sort of shift the discourse here, because historically, copyright is not about protecting content creators. If you go back to the origins of copyright, it's about protecting the rights of content distributors. It's about, literally, in merry old England, how many, if you've got a new book, how many copies each printer can make. It's literally a right to copy. And if you look at the US discourse in terms of technology, this is all about protecting content distributors in the US, whether it's music, film, where the big money is in the US. So the rhetoric of protecting creators and copyright is just that. It's a political rhetoric. In point of fact, it's all about protecting content distributors.
Thank you. That was quite passionate. Thank you very much. So, in going back, anyone else would like to say anything about their submissions? Please, Caroline.
Thank you. Is this on? Yeah. So Caroline Greer from ETSNO, the Telecoms Trade Association. Yeah, we responded to the consultation, very challenging paper. You know, people often forget that telcos are also content providers, ISPs, etc. So we had a very wide range of views in our paper. I guess when you said at the start, throw out some words, enforcement was the word that came to my mind, because telcos sort of get caught up in the intermediary liability debate and sort of dragged into the enforcement discussion. And I think from our perspective, you know, enforcement to us always seems like kind of the sole solution to the copyright debate. Whereas we would sort of take it more from, you know, we need to look at this debate in a more holistic way, and let's look at, you know, more ways of producing legal content, not just looking at it on the defensive side. I mean, I'd be interested to hear the panelists' views on how they see intermediary, the role that intermediaries have in the enforcement side. I mean, our view, of course, is that, you know, the system is working quite well, that, you know, ISPs, telcos collaborate in a very meaningful way. I mean, we sort of are always uncomfortable with the discussions around where we're put into a kind of a judgment role about, you know, making decisions on certain things. Luckily, a few ECJ cases have come up which sort of do very much present the view that there are, you know, a number of rights that need to be balanced. So, you know, we think things we're moving in the right direction there. But yeah, I mean, it always sort of comes back to the enforcement issue, to the role of intermediaries. So I'd be interested to hear some views there.
Thank you, Caroline. And if, oh, please go and we'll react to that. Yes.
Yeah, hello, my name is Martin. I'm here with the New Media Summer School. And I had a project around that consultation. I mean, we worked heavily also based on the website of the Copy Wrongs, admittedly. But I had a project to bring that consultation also towards young people, working with youth councils, and we tried to also consult in schools. And if you look at the consultation, it was hardly understandable for any young person. What we had to do is really do these, reduce these abstract questions to a more abstract and more general level to really find out what the positions might be and then interpret. I think the Commission is doing the same thing, but if you look then at the consultation processes, if the people that are collecting answers from people that are not right into that process, and then the Commission is trying to find also an abstract level from all these derived and put down to the essence consultation answers, I'm not sure that really the message is going across very well in that whole process. And I also don't feel that a lot of young people, I think also a lot of average users on the internet would really understand. And while I assume our contribution went on the monetarization of content quite far from what the artist said earlier. I think on the understanding on really making copyright accessible for the average user, we share very much the same position there.
Thank you. And I would really like to flag up exactly what you said. We haven't done, and I think that this is a collective responsibility issue, we haven't done a really good job, especially in the context of copyright, to explain what it is all about to the younger people. These are the people who are using the internet, these are the people who are going to create eventually, and they're going to innovate. And the copyright law currently, at least the way it stands currently, is extremely detached from someone who is 20 years old and has grown up using this or this. So it is very important that any consultation actually exactly brings us back and explains the issues in a way that young people are able to relate. But going back to the issue of intermediary liability, which is another Pandora's box, nobody really knows what's going to come out of that once you open it. I know that as a moderator I'm not supposed to be making a lot of comments, but I am going to because I have the microphone right now. And the intermediary liability is not just about copyright. It is also about retaining a balance on the internet, of how the internet works, and it is also about innovation. It is not accidental that intermediaries have been excluded from liability. And it's not accidental that because of that exclusion, we have seen so much innovation taking place by those very intermediaries. The fact that they're able to invest on the internet, the fact that they're able to create new things on top of it, the fact that they're able to innovate. That doesn't mean that intermediaries do not have a set of responsibilities. But the idea of assigning intermediaries a role that they were never meant to be having when they were entering this space, and that role was to check what comes in and out of their channels in terms of content, so they know what Konstantinos is sending to Ellen, and oh, we don't really like that, so we take it down just because we are afraid that if we don't, we might be sued, we might be dragged to court, and copyright lawsuits are lengthy and expensive. Nobody really wants them. Is something that we really need to try to avoid. We need to come up with a system of collaboration. Collaboration is already there. Perhaps it needs to be strengthened, but the solution, at least from my point of view, is that we do not really need to actually start asking them to do things just because they're the Googles or just because they carry traffic through their channels. And I will stop here because I just suddenly became very excited. And I'll pass it on to, before you go, if you can let very briefly our panelists react to the question from Etna, it will be great. Matthias, just briefly, please.
It is our experience right now that there is a certain degree of overblocking. There is a certain degree of under-checking about the validity of claims being made. And whenever the term collaboration comes up, this is something I'm highly sympathetic to as a Wikipedian. However, it feels like this term is also used to describe a process of privatization of law enforcement, where the person I'm no longer able to respond to is not the law enforcement agency that follows a specific set of guidelines, but then rather black box of corporate procedures that go usually towards the risk avoidance rather than the fulfillment of given rights and privileges. So whenever possible, and this is a good occasion, I refer to the research that has been made by groups to see if bogus takedown notices are being vetted, if there is anyone actually checking them, and the overwhelming results is no person, no algorithm is actually checking them. Stuff gets blocked. Whenever you are able to come up with a fancy mail header and a few claims, and this should be avoided.
Thank you very much, Matthias. Ellen.
Okay, so on internet intermediary liability, I think we need to seriously assess the effectiveness of these regimes versus other initiatives like providing greater access to content and other forms of self-regulation that move down the access corridor, as opposed to simply thinking about it from an enforcement perspective. There's some really great research that's been undertaken by, for example, Professor Rebecca Giblin, who has compared a lot of the existing graduated response schemes in place throughout the world and measured their effectiveness. I want to return to the comments that were being made about educating young people about copyright, and I think one of the profound problems we have with copyright is that in the internet environment where the act of copying is ubiquitous, it just doesn't make any sense. You look at some of the changes to the UK copyright laws, for example, and we're talking about things like making it now legal to use an interactive whiteboard in the classroom because that was an infringement of copyright, but using a blackboard was fine. Like, this is the type of thing that we're talking about because all of these digital uses inadvertently require the act of copying. I've said before, at some point, hopefully, we'll move away from the act of copying being central to the way we talk about copyright, which I guess means we'd have to change the name. But we're just going to keep encountering the same roadblocks every 5 years, every new innovation. And when we talk about permissionless innovation, my concern is, in a lot of jurisdictions, we're talking about any new use online could be presumptively illegal, regardless of whether there's harm to the copyright holder. And that, I think, is something that we need to seriously think about, and not in a sense of, well, how can we then undertake a licensing process to make it legal? It's, well, actually, what impact? Let's return to the true nature of the three-step test and whether there is harm to the copyright holder.
Well, on the question of intermediaries, I'm not qualified to speak about, the role of ISPs there, but I'd just like to remind people that indeed libraries have also played this role of intermediary when it comes to granting or providing access to ICT and to the internet. And I think a lot of you may have heard about the cases that emerged after new legislation in the US after 9/11. I think it was the Patriot Act, on the basis of which at some point libraries were approached and librarians were approached by government agencies with the request to disclose the lending, the borrowing behavior of their users, and also with, I think, requests regarding the usage of internet PCs in their premises, etc., etc. And I think a very lengthy lawsuit occurred, which only after quite a while resulted in a, what's this called in English, non-acquittal? No, if you're sort of like not sentenced. So the libraries basically were, or the librarians, in fact, because it was individuals who actually who refused to hand out these data to official authorities, government authorities, and who were then, put on trial. They were acquitted. That's the word that I was looking for. And the other thing that I wanted to mention was on, the second point that you made about. Just remind me, what was your second point? Well, we'll get to it, back to that later.
Right?
Thanks. Please? I think you have a question or a comment.
Just, my name is Max Grafenstein. I'm a doctoral researcher at a research institute in Berlin, specialized in copyright law. And I just would like to add something what you mentioned before. So if it's about balancing the different interests of all participants of cultural markets, I think the main problem for this right balance is, especially in the copyright directives, this assumption that only a very high level of copyright protection can foster innovation and creativity on the European market. And this is an assumption, and there are no empirical studies that really can prove this assumption, that it's right, or the opposite. And so I think this should be really posed, or should be questioned for changing copyright law, because from this assumption you conclude, for example, this is systematic, that the copyright protection for the copyright holder is the rule, and then the exceptions must be interpreted very strictly. Yeah, and this distorts a bit the balance. It's just a thought.
Thank you very much. I think, yes, you also have an intervention. Thanks.
Thank you. My name is Christian Sommer. I represent the MPA in Germany. And of course, we also submitted quite lengthy comments to the copyright consultation. And I'd like to go back a little bit. Unfortunately, I just got the microphone, so the discussion advanced a little bit. But to what was kind of mentioned earlier, and I heard like some words outdated and copyright was broken, but I also heard the words evidence, for example, and like proof, for example. And I would say, and basically challenge some of these assumptions, and basically what was kind of used to frame this discussion, namely that copyright is outdated, for example. I don't think so. I think copyright is not outdated. I think the current framework that we currently have in Europe and also in Germany gives flexibility for basically the whole ecosystem and the environment to react basically to technology developments, to basically provide a framework that is still fit for purpose and doesn't need to be turned upside down, basically. We have seen many ECJ decisions over the past couple of months and years that actually clarified some open questions in the context of how to basically apply the current framework. And just because the copyright directive is some 10 plus years old, I think doesn't make it outdated. I think it provides the flexibility, and there is no basically evidence that it's necessary to basically change fundamentally the copyright system as it is. You could use the same argument, because intermediaries were mentioned as well, for the e-commerce directive and the liability rules. Back then, basically, it was the assumption that just like it was just dumb pipes that were kind of the internet that advanced as well. We don't have like dumb pipes anymore in terms of technology and in terms of the internet infrastructure. With the same argument, you would need to basically do the same discussion with respect to basically those pipes. Think of search, how search advanced over the past couple of years, how important and what a fundamental role it plays right now. And back then, the framework for search basically was based on the assumption that it is kind of a dumb technology that doesn't have like any sort of say intelligent component. But I just want to make the point that I think the copyright is fit for purpose, that those who actually advocate for change and reform basically need to prove why, and I haven't heard like any convincing, I would say, argument that copyright is broken, that it needs to be fixed. I think this is the second step before the first. The first step really like to provide the evidence and the proof that there is actually the need for such a reform, and that's, to keep it brief, my comment.
Thank you very much. I would like, oh, there is another question? Sorry. I have you at my back. Thank you.
Thank you. My name's Annie Mashon. I'm a former British intelligence officer and now a writer, amongst many other things, so a fellow creative. I do disagree very much with the last statement. I think the internet has broken copyright totally, and in fact, when I publish, I always use Creative Commons licenses so that anyone can read my stuff for free, download it, copy it, use it, whatever. But the argument I would suggest about why copyright is dead or is dying is also for security reasons, because at the moment we have a situation where and I agree with the gentleman at the table who said that the distributors are the beneficiaries mainly. The distributors run an old 20th century broken business model, in my view, and they're fighting a very violent rearguard action to try and prop up this failing business model in the face of internet advances. And doing this, they are getting involved in trying to SWAT team raids against people like Kim.com, who ran the mega upload site in New Zealand, where we see students being extradited to the US from the UK for just having a website that acts as a signpost like Google does or YouTube does to copyrighted material. And we also see them lobbying the governments and, by definition, the intelligence agencies in order to develop tools so that they can be more and more invasive to try and find out who is downloading copyrighted material of whatever nature across the internet. So we have a situation where they are now pushing for deep packet inspection, which means going right into the little tiny bits that are being passed across the internet. And if they get that, then none of us is safe on the internet. None of us will be able to use proper encryption. And of course, the spies love all these types of innovations as much as the copyright beneficiaries. So that's why I think it's broken. I think we all need to be very aware of this, not just because of the damage that's done to individuals, but also the damage that will be done to all our freedoms on the internet if these laws are allowed to continue and indeed expand. So that's my view. Thank you.
Anyone else, any questions before I go to our panelists and hear their reactions to those passionate comments from both sides of the pond, please?
I'm very happy to be here. I think the libraries have a large duty to go into the countryside, into the villages. We presently do some pilot projects to really not forget the book. In the 80s, we tried to bring the canyon of coded and non-coded data harmonization with different cultural expressions, different science systems together. And I think to really reach acceptance, follow my tweets, and I feel it is really high time that we overcome all these canyons and these mindsets that they are symbol, icon, and index, and it can be even dynamic. So I think libraries have the duty to not forget the book, but to go to integrated approaches as we do in Germany with an Institute for Sustainability in Work, Learning and Culture.
Thank you. So, okay, if there is no one else, I can't see anyone else, I will start with Matthias. Reactions?
The first reaction is gratitude for your input. The second one is that on a certain ironic level, I completely agree with Mr. Sommer's comment in the need for more data. We might have completely different conclusions, or maybe different presumptions, or whatever else. Maybe we live in different worlds. But I would argue that the concession of having a broken copyright system has already been made during the orphan works debate by everyone involved, including the copyright industry, which is affected by orphan works as well. So, and you might say that there has been a small patch attached to the problem of orphan works by the directive of orphan works and certain national implementations, but or you could argue that this doesn't affect copyright as such. It's simply a nuisance that the fact that basically the 20th century wealth of information is no longer really usable. I would argue otherwise. But at least I thought before you comment that we were already beyond this point of debating whether there is a problem. Certainly, and this is important, and there are some echoes of this sentiment here. the need for proper evaluation, and the need for data, the need for a certain mindset that is questioning the previous assumptions. I mean, we entered this discussion here under the assumption that copyright is needed. I'm fine with entering such a discussion here. However, every bit of the current copyright legislation should be subject to questioning whether it's needed. And I would start with copyright terms, for example, because they seem to be a cause for certain problems we all encounter. So that's my statement.
Thank you. Ellen.
Okay, there were so many great contributions. I'm going to try to touch on each of them. The first about copyright, the current system doesn't need to be changed. Were you talking about the InfoSoc directive itself? Okay, so perhaps I'll just say what we said about the InfoSoc directive. So first of all, exceptions and limitations are not mandatory, they're optional, which has resulted in a patchwork implementation across member states. So first of all, that's what we would want to change about the InfoSoc directive. The second is last year's De Wolf study fundamentally questioned whether the right of reproduction for libraries and archives in the InfoSoc directive would facilitate new uses like text and data mining or digital preservation. So if we're in a situation where to undertake digital preservation of our own collection material is an infringement of copyright in the EU, then I'd say yes, in that respect, the InfoSoc directive is broken. The second point that I wanted to touch on was returning to the ways in which how we use material online is increasingly being monitored or controlled by different copyright holders, because I completely agree with you. This is something that libraries are very familiar with now. When we license databases, we are also permitting the monitoring of those databases by publishers for certain activities, and we have found ourselves in situations, for example, where a publisher detects what it considers an illegitimate use of a database, it will remove access to the entire database for the entire university population. So we're talking about penalties that go beyond what we would think would be legitimate in this context, as in to have an entire university population denied access to mandatory textbooks for monitoring, for uses that were monitored on that database. I think that's a concern. I also see real concern for everybody outside of this room, people who aren't aware of copyright, of how actually our online participation in science and culture is being shaped by the types of technological protection measures, by the territoriality of our licensing regimes, without us even being aware of it. We are increasingly moving into a situation where if you're a kind of unknowing consumer on the internet, you take a passive approach to the content that is presented to you. If certain content isn't available in your country and you don't have the resources to otherwise locate it, then you just encounter a dark hole in the cultural record. The types of things that we now see that prevent mashing up and remixing of content, I know that it'll only be some creators who want to undertake it, but I think of the ease with which these types of innovative uses of copyright material could take place before the internet. Like, was it William S. Burroughs who did the newspaper? He cut up all the pieces of newspaper and then dropped them on the floor and then wrote a new story based on how the newspaper fell down. So I think those kinds of things that don't require a level of technical expertise, but just this ability to engage with, reinterpret, explore content is being increasingly eroded. One final comment, because I know that Konstantinos is giving me the eye. When we talk about access and internet intermediary liability, and I just want to go back to my original comment that I think we need to focus on access first before we go further down the path of further internet intermediary enforcement mechanisms, because just to give you one example of when I arrived in Germany, so I would say, at least from my perspective, this aspect of access to content in Germany is definitely not working. So has everyone seen that Sia chandelier video? Some people are nodding, but if you're based in Germany, you're probably going to say no, because basically what I discovered yesterday, so I'd seen a lot of parodies of this on the internet. I'd read a lot of blog posts about how fantastic it was. I saw that it had been presented on Ellen. So I thought, well, now finally I'm going to watch it. Got to YouTube, put it in. Sears artist video page. This is the artist. You can't watch it in Germany because the YouTube has been in a contracting dispute with GEMA since 2009. They've been able to license it in 45 other countries, but in Germany, you just can't access it. And to me, that's kind of like a profound problem in terms of, to me, it goes beyond, well, I'm sorry, you just can't access that piece of content, to we're kind of shaping the cultural engagement that citizens have based on where they're located, and that is a problem for me.
I'm obviously very grateful for the sort of like confirmation of the societal role of libraries that was in one of the comments, and obviously this is not the topic of the conversation that we're having here, but just to add that many libraries in their strategies, and also many countries in their national strategies, define libraries in the future as public third spaces, be it physical or also virtual spaces, where libraries support citizens in exerting their rights to education, to access, to political participation, etc., etc. One other point that I wanted to comment on, and that actually is the point that I was referring to earlier, which was mentioned by Ellen, that's the conception of copyright still being combined with something physical. This is basically what also the current model of, for instance, the e-book service in libraries in Germany is based on. Germany has adopted e-books quite early, I mean the German library community compared to other European countries, and a number of service providers have emerged, aggregators who basically, for the libraries, take care of the licensing process and the contracting with publishers, so that libraries don't have to do this on themselves, and they basically just subscribe to the service for a certain fee and then can choose a set of titles which they can offer to their users. The background of this arrangement is obviously current copyright, and still the idea that there is some sort of like physical copy involved because it's all based on downloading. Now, the system works quite fine to a certain degree, although some publishing groups are not participating, some big publishing groups. But the problem that we see now is that this is sidelined by technological development, because the models of other countries who now start to offer e-books through service providers such as libraries is based on streaming. And streaming obviously is going to be the future, you know, for this particular way of service delivery, and has all sorts of different, you know, implications compared to the German model, which is still based on downloading, where you have at least, you know, interim physical copies somewhere on somebody's computer. So I do think that that copyright probably needs to evolve there to also cover this area.
Thank you. So we have 15 minutes left. I would like to, you know, you have been asking questions. Please ask, this is your chance for interventions, comments. I see John is having a question, and please.
Thank you. I just want to, I agree strongly with Ellen on this, and I want to point out another place where copyright is really broken if we move to an international standpoint, and that is the availability of digital content globally is really problematic in the developing world. Copyright is completely broken in the developing world because no one is going to pay 10 euro for a movie when that will feed their family for a month. And piracy is piracy isn't piracy, it's just like I want to go watch the movie. And finding access to that content, it's out there. I mean, I'm actually working in the Gulf right now. No one even thinks about whether I'm violating copyright or not among my students. That's for sure. So, in the OECD world, yes, copyright has some teeth, but outside there, and most of the rest of the people in the world are outside the OECD. You've got a huge group of users who are now coming online. This is like the next sort of chunk of new users for the internet, and they're all coming from places which are less affluent, and they're not going to be willing to accept copyright restrictions for content because they just can't afford it.
Anyone else? Questions? Come on, come on. Oh, thank you, Caroline.
Thanks. So since we're on the international theme and going back to my point about collaboration, I wonder, are there any views on the American CCIA system, which appears from the first report that appeared recently to have worked quite well? We're interested, we look at it from a European perspective. I wonder to what extent that could be replicated in Europe, because the European market is way more complex. But any views from anybody on how that's working?
Anyone want to take that question? Well, I can take it then. And that was what I was referring to in the beginning when we started this discussion about voluntary initiatives and self-regulation, and whether perhaps this is an alternative way of thinking of addressing some of those problems that we see emerging and some of the concerns that all parties are having. I was referring actually to the copyright alert system in the US. So this was a system based on, for those of you who are not familiar with it, it was a collaborative effort between various ISPs and the content industry in order to come up with a set of rules or principles that would be able to address the issue of copyright infringement and downloading of illegal content, well, of copyrighted content, better yet. So the system went through a lot of phases. And this is not a criticism. It is a brand new system. It was meant to go through these phases. A lot of lessons and mistakes were made, and those mistakes were taken on board. It was over the discussions, the course of the discussions, and over these collaborative efforts, more and more transparency was appearing on the system. It operates on the basis that users are sent 6 notifications. After the third one, there are some sanctions, but nobody gets disconnected. And that was a very hard-fought battle by certain groups, certain interest groups that participated in its formation. So basically, we're seeing slowing of bandwidth, or or any other measures, but nobody gets disconnected. The great thing about it is that it has some checks and balances that we do not necessarily have experienced in other parts of this copyright debate or other initiatives that we see in other parts of the world and outside even the United States. There is an appellate body. The advisory council is multi-stakeholder, which is a huge win, if you want, for a system that was not able to operate traditionally under multi-stakeholder structures. So this is an indication that also copyright discussions are opening up to different views. And yes, the first report was positive. I think that, and I know that there are more things that need to be addressed. There are more accountable processes that need to be in place. But as far as voluntary initiatives go, especially in such a heated and difficult, complex, controversial issue, I am very optimistic that this is a system that potentially can actually prevent a lot, not prevent necessarily, but can address a lot of the concerns that are out there. And legislators and policymakers can actually learn from much of the process and much of the substance. I know that a similar initiative is taking place in the UK, and I am at least reading. I haven't had the chance to read the actual the substance of these of the outcome of these initiatives, that they're not necessarily following the path of the United States. So it will be very interesting, and this goes back to we literally all need to sit down and start talking about what is the best way to address this issue. It has gone, we heard it from John, there are some parts of the world that apparently, downloading copyrighted material is sort of okay. Well, that is problematic, okay? And I don't think that anyone in this room is going to advocate that, yes, let's all start downloading movies and music for free. We need to find a system that is able to do this. In order to do this, there needs to be a lot of information. There needs to be, I am not going to use the word education because I personally find it a little bit tricky, but we need to inform and we need to be able and provide facts, evidence. We've heard that a lot also. We need to be able also and move the discussions into finding solutions. We have identified the problems, we have identified the challenges. Right now it's time more to start identifying those tools that will allow us to address the issues for libraries, which are essential parts of this system. They will be able to address the issues of Wikipedia. These are new businesses, there are hip businesses that everybody likes, that everybody wants to use, that everybody wants to provide content. And when you provide that content, you shouldn't be really scared as to whether your content is, well, as to whether you're going to be sued, as to whether you're going to be extradited, as we heard before. Generally speaking, the internet needs to facilitate creativity and innovation. So I will stop here again. I'm ranting, I think. So I will just, any other questions before I go, please? I need to pass you. Oh, is there? Okay.
Hi, my name is Matthias Bjarnemalm. I'm from the Swedish Pirate Party. I was a little bit surprised why you would assume that no one in the room would advocate free file sharing or free downloading on copyrighted content.
I apologize for the assumption.
Yes. Basically, sharing of culture and knowledge has been a human instinct forever. We've always done this. We did it before copyright, we did it before the internet. The only difference is that with the internet we've been exceedingly good at it. And suddenly that comes into conflict with a copyright regime that was never intended to regulate normal people, but to regulate business. So I would say that the instinct to share is not the problem. The problem is the copyright. And if we can fix that, then we can have these free downloads. And that will actually boost the digital economy because it will create a demand.
Thank you. Yes. Oh, you already have one.
Turn this. Is it on?
I don't think it's on, so let me give you this one.
Yeah. Okay. My name is Sander Venema. I'm a blogger and web developer and entrepreneur. And I really agree with Alan's statement about the chandelier video, that it is not available in Germany. You clearly see that the content industry is having this divide and conquer policy and trying to extract as much money as possible and clinging on to a 20th century business model where for thousands of years or for millions of years, in fact, humanity as a whole, society as a whole has benefited greatly from sharing openly and building upon each other's work and standing upon the shoulders of giants. So as a whole, as a society, I think copyright needs to reform and really needs to move on. And that's why initiatives like Creative Commons, for instance, are such a good idea, in fact. Okay, that was it. Thank you.
Thank you very much.
Just a general comment. I need to say that I'm not exactly the fan of all this copyright stuff. I'm a law student and I have a harsh discussions about all this copyright and copyleft stuff. I myself am from Georgia, and I don't know if you know that country, but still. We are a developing country, which means that we are taking Germany, USA, developed countries like that as an example, and their legislation are shaping ours. So what I'm really worried is that the YouTube that I enjoy so much right now back at home, and where you can watch all the videos one can think of, will soon not look like that if we are taking examples of Germany and USA. So I'd like to see really that the German legislators or legislators at EU level will soon reform all this copyright legislation so that the users are happy as well. Otherwise, I'm not sure I'll be sitting here for the next EuroDIG, and maybe instead I'll be in jail because I'm too addicted to Pirate Bay. So that's just a general point of view of mine. Thanks.
Thank you very much. Do we have any remote participants? Nothing. So, you want to make an interview? Okay, sorry.
I'm glad for the Creative Commons comment from over there. Basically, I think that's actually proof that the system is working, because Creative Commons is existing in the current environment. It's based on the existing rules, and to me it is evidence and proof that the current environment is fit for purpose and basically provides like the framework necessary for Creative Commons and alternative licensing models to basically be developed and flourish basically. So I don't think that's kind of contradictory. I think it's it actually proves that point that it's flexible enough.
So, we have 5 minutes, and I don't think we have other questions. I will ask each one of our panelists to just literally 1 minute, just sum it up. And I don't want you to sum up. I want you to approach your minute as to what you got out of this discussion. Okay, so what are the messages that you have received from all these people that have made an intervention and that you are going to take back to your respective bodies and organizations? Guido.
Wow, that's a task. Well, as I said before, one message that I've received is I sensed quite some sympathy in the room for the cause of libraries, or perhaps the people who don't really think that libraries should have, the functions that have been described before, just were very politely silent. So I really will take this back to our team that's also involved in lobbying work and that, for instance, has quite successfully worked on getting at least 2 points into the coalition treaty of the current German government, i.e. that the coalition will consider the introduction of exceptions limitations for culture and education in legislation in copyright in Germany, and that it will also consider granting libraries a right to license e-books, not on which conditions, but simply that they can do that. And I would shamelessly like to exploit this opportunity to point you all to our campaign again, the right to e-read, and a petition that has been set up on change.org. So if you type into change.org libraries, you should actually directly get to the petition of EBLIDA, the European Library Association, where European libraries basically asked the European Commission for a framework that allows libraries to provide digital content as well as print content. Thank you.
Okay, I'm kind of not going to do what you told me to do, but I will do it in 1 minute. Okay. Because I've heard a lot of love in the room for the need to reform copyright, but I also want to thank our colleague from the MPA, because I'm conscious that we didn't have any people representing industries on the panel, because there are very different views as to how significant copyright reform is and how greatly the environment means to change. So I think I hear these kinds of conversations all the time. I have a lot of these good conversations that reflect my views and how important it is, but what is missing is influence and action at the level where it is needed to actually reform the laws. Like, if we think they need to be changed, then we need to be much more strategic in how we approach this. We need to mobilize. We need to ensure that there is momentum here to move towards reform if we think that this is important. Basically, I would just say that we need to take this conversation outside of the forums that are really just among our friends, and to the policymakers and to the legislators, and create momentum for this.
Thank you, Ellen, even though you didn't do as asked. Matthias.
So far, I'm happy for the responses, and I'm trying to remember the organizations you're coming from, because I would like to see you again the moment the white paper is being released and the impact assessment, and then to see if the Commission chooses to provide a forum for you to participate in this one, to see if necessary and what kind of change there is possible. I think the only organization so far I've seen who has been advocating against tremendous reform has fortunately been here next to the table, maybe next time on the table. But I think the yeah, of course. The one thing I really took out from this thing is it's the inability to enter this topic without any kind of premise. And I think the conversation would have been completely different if we would have agreed on asking for the need for copyright at all, or the intention of going back to a scenario where you mentioned, Matthias, you called it instincts. I think it's a lovely term, where the instinct of sharing is being acknowledged as something inherently good, which currently isn't from the point of copyright law.
Thank you all very much. I would like to thank our panelists as well as everybody who has been here making an intervention or not. This has been, as always, extremely exciting. So thank you very much and enjoy your lunch.